observe that we are a board of 4 this evening. One of our members is out of state and on vacation, and the other member had a medical emergency to which he needed to attend. The first order of business this evening is the minutes for July 21, 2016, which I have edited and circulated to all board members present tonight. I'd like to ask for the record if they've had an opportunity to review those minutes of July 21, 2016.
Yes.
Okay, there's one small item that was missing on those, and that was the second to Vice Chair's Clark's renomination to be Vice Chair for this fiscal year, and I have determined that it was Mr. Maynard who seconded that nomination. So if that information could be inserted in the minutes for July 21, 2016, Madam Clerk? Okay. That was the only item that I wanted to bring the attention of the board to. Does anyone have any questions or comments or changes or amendments that they'd like to make? Nope. Do I hear a motion to approve the minutes of July 21, 2016 as written, but for the addition of the noted second of the Vice Chair's renomination as Vice Chair for this year, that second again by Mr. Maynard?
I move to accept the minutes of July 21st as amended.
Do I hear a second?
Second.
All in favor?
Aye.
Okay. So we go now to the only other item on our agenda for this evening. This is a request that was then made by the petitioner, Borrego Solar Systems, Inc., through its legal counsel to rescind the previously granted variances in case number 16-974 without prejudice. And I observe that legal counsel is present. I also observe for the record that there has been a lot of discussion since our decision on case 16-974, and there have been some, I don't want to call them negotiations necessarily, but there have been discussions between legal counsel and his client, and also certain parties representing the town, not any members of this board in particular. But these conversations have led to some, I think perhaps some confusion about why we're here tonight talking about a rescission when recently there seemed to be an indication that that was not what was going to be requested this evening. And we're within the 48-hour rule on this because I received notice, I think it was just about 24 hours ago, that perhaps you and your client were going to go in a different direction, Mr. Cirque. So I just kind of want to flesh this out for the board.
Originally, when your agenda was put together, it stated that Borrego was requesting that the zoning board rescind its vote. Since that time, however, Borrego's position has changed in light of much of the communications that you've referred to. And Borrego's position tonight is that it is not requesting that your vote be changed. So with that, it would appear that there's nothing before you, because I don't believe that you can, on your own, absent a request from the petitioner, rescind your own decision.
I don't think that we would entertain such an action, but for the sake of the public who may or may not be watching this evening, this was a properly noticed meeting this evening, and I did not want to simply put out an email to the parties in interest or anybody up here that we were not going to be having this meeting. So here we are tonight, and you are requesting that rescission, or that decision not to rescind our decision 16-974. Is that right, Mr. Cirque?
I am not requesting that you change your vote.
Are we going to be revisiting this anytime in the future so that we don't have to go through this exercise again?
I don't know. Based on the events of the last 2 days, I fully expect that the planning board will file its appeal from your decision. And where that leads, I don't know. I can tell you that based on the information that Borrego received from Eversource as recently as last Friday, the financial viability of the project is being reassessed, not only because of that, but also because of the financial requirements of acquiring an easement or fee from Edgewood Boggs. So the combination of the regulatory requirements of Eversource and the financial requirements of Edgewood are such that I cannot see, I cannot determine at this point whether, to answer your question, Mr. Gray, you'll see this project back before you.
I thought that the easement, that you folks had already reached an agreement on the easement.
It was, the documentation I had was that they agreed to give us an easement subject to mutually agreed upon consideration. And that mutually agreed upon consideration is still being negotiated. So the concept of granting an easement was agreed upon, but the price tag for it had not been. So I just don't know whether we'll be back, but I hope we will. But
So I think I'm hearing you say that it's possible that this project on which the ZBA granted the variances may not go through at all.
that's possible. That's possible. And
Can you give us some idea as to when you are likely to be able to tell whether that's going to happen or not? Ballpark.
I would assume within the next 2 months. And if it does go forward, the form in which it would go forward would be a new petition to this board and a modified petition to the planning board with noticed public hearings all around. But I hope to be back. I just don't know whether the numbers will warrant going forward. But if the numbers do warrant going forward, it's clear in my mind how it'll have to happen with both boards, and it'll have to be noticed public hearings all around.
Well, I would ask you to do just one thing for
Sure.
us, and that is
Sure.
when you have arrived at a reasonable degree of certainty in your
Let you
mind
know.
after speaking with your client, that this is either not going to go forward or will be going forward, but in a different form, to please communicate with me.
I will. I certainly will. I mean, you're entitled to that. You've invested your time and your energy, and I appreciate that, and Borrego appreciates that. Certainly.
Any member up here have any questions or comments?
I hope it goes forward because I think it's a good project, and it offers benefits to Carver residents that otherwise they would not have.
So at this point, our decision in case number 16-974 stands.
Right.
And just to respond to what you just said.
Yeah.
This, and also something that I've said recently in a different form.
Yeah.
When we spoke with the planning board in joint session. This board has not always granted requested relief, zoning relief, in connection with solar projects. And in particular, one of those projects that we denied the relief was to your client, Borrego, coincidentally, on a project located on Meadow Street in Carver. So we look at each case as,
Was I involved in that?
you were not,
Yeah, okay.
Yeah.
Yeah.
so you didn't lose that one, Mr. Serby. That was different legal representation.
No,
But we look at all of these cases, for the record, we look at all of these cases as individual cases. They're all snowflakes to us. They all have their particular and peculiar factual characteristics, and we consider each and every one of these carefully. So some we decide based upon the facts and the law are appropriate, and we vote accordingly, and then others we have turned down, like that Meadow Street project. So in this case, we felt that it was appropriate. The board has spoken, and we thought this project was appropriate in view of a number of different factors. We appreciate the opinions of others who may disagree with us. You know, the bylaws are present for a reason,
Yeah.
and they can also be excused, if you will, for good reason, based on the facts and the law. So we always have utmost in our minds the best interests of the public in town. And I will say, without getting too much into the specifics of this particular case decision, that there weren't very many members of the public to protect in this particular case, because the project is a half a mile off the road.
Yeah.
And it would take a very strong Nordic yodeler to be heard to the next closest residence. So, do you yodel, Mr. Mallon?
No.
Okay.
I know that from having appeared before you a number of times, that variances from this board are hard to get because you follow the statute strictly, as you should, and you make the applicant prove that he satisfies the statutory requirements of uniqueness, hardship, no detriment to the public good, and no derogation from the intent or purpose of the bylaw. And so I understand what you're saying when you say that you don't always approve projects. I mean, variances, even in cases where the facts seem to cry out for them, you still require, to your credit, that the applicant be put through his paces. So I understand that.
So I hope, and I think I speak for the rest of us up
Yeah.
here as well, I hope that at some point in the near future, we will
Yeah.
hear from you, and you'll be able to give us some direction as to what your client would like to do going forward. That obviously is up to you based on your discussions with your client. We will not obviously be involved in any of that.
Yeah.
But again, once the decision has been made and you
I'll
have a
let you know.
reasonable degree of certainty in your mind as to what's going to happen here, I would appreciate knowing this is something I think that the planning board is interested in as well, and so they would probably appreciate knowing also.
Given the position of the planning board with respect to the importance of the frontage in their mind, it's likely that if we came back, it would be on an enlarged site, a site which would have 60 feet of frontage from Edgewood at the northern portion of the site, and then the rest of it is as you know it. And that is why, if we came back, it would have to be a completely new petition, because the enlarged site means that there's an enlarged universe of parties and interests that have to be notified. And if we came back to the planning board, however, since the project itself is still on the same piece of property that it was always on, and their focus is on the use, it would be an amended petition, again with the same universe of abutters, but it would be a modification of what they previously granted. So that's the procedure that it would go in, and in the best of all possible worlds, the hearings might occur on the same night, separated or whatever, but so that the notice could go out in the same envelope to both. But again, this is all premised, the big if is whether the numbers add up at this point between
this-
Eversource and Edgewood. So it's a monetary situation, and but that's all I can say at this. That's all I know.
This board, as you know, Mr. Cirque, will express no opinion at this point with
Of
regard to the outlines of this intended plan or hoped-for plan,
Of
if
course.
it ever does come to fruition. We leave that to you and your client. We reserve judgment if this plan is going to be changing. All we will do tonight is speak to your request at the time it was made for rescission. And do I hear a motion not to take any action on that request at this
So
time?
move.
Do I hear a second?
I'll second.
Any further discussion on this?
I guess I'm rescinding my request that you rescind.
That's right. So, all in favor?
Aye.
Okay. So that rescission of the request to rescind has been denied, or has been approved, I should say that. Request to rescind has been approved. Okay. So that was the major order of business tonight. Mr.
Mr.
Nowell.
Chair, is there anything else pressing that you need to vote for? Because there is a regularly scheduled meeting of the earth removal, and they have asked very strongly for my presence, because I am the one witness to a discussion with Mr. Vaughn.
Mr. Nowell, would you like to make a motion to adjourn?
I would like to make a motion to adjourn, yes.
Second.
All in favor?
Aye.
We stand adjourned.
Thank you
Thank
very
you. Good
much.
evening.
Thank you.
Okay, thanks very much. Okay.